be seated. Good morning. Welcome to the Idaho Supreme Court, Friday, January 23rd, 2026. We have one matter set for hearing this morning, case number 53264, the Committee to Protect and Preserve the Idaho Constitution versus the State of Idaho and the Idaho State Legislature as intervener respondent. Petitioners, the Committee to Protect and Preserve the Idaho Constitution et al. Are represented here by Marvin M. Smith, who I understand will provide opening argument, with Marvin K. Smith providing rebuttal. Gene Schroeder appears only in this matter. For the respondent, State of Idaho, acting by and through the Idaho State Tax Commission, we have Michael Zarian, who will present argument with Alan Hurst appearing. And we also have Jeremy Chu, who will appear for the Legislature and argue with Morgan Goodwin appearing only. Did I get all that right? Okay, very well. Counsel, do any of you have anything preliminary for us before argument today?
None, Your Honor.
No, very well. Mr. Marvin M. Smith, you may proceed.
Chief Justice, Justices of the Supreme Court, Counsel of the Court, please. From July 4th, 1889 to August 6th, 1889, the delegates to the Idaho State Constitutional Convention met to frame a new constitution for a new state. They created the obvious and necessary judicial, executive, and legislative branches. But interestingly, and also by way of necessity, they dedicated an entire article to public education. And for many, that article is the crown jewel of the Idaho State Constitution because it secures, establishes, and maintains a general, uniform, and thorough system of public free common schools for generations of Idaho children. Based upon that promise, the petitioners here today bring this original action to petition this court to issue a writ of prohibition forbidding the Idaho State Tax Commission from giving effect to, implementing, or carrying out the Idaho Parental Choice Tax Credit program created under House Bill 93 and now codified in Idaho Code sections 633029N and 672030. The program is unconstitutional because it publicly funds and maintains a system of schools that are not general, uniform, thorough, public, or free, and the program also offends and violates the public purpose doctrine, which is implicit in the structure of the Idaho State Constitution. The court, when passing on the constitutionality of statutory enactments, looks to the primary object to determine what the intent of the framers were at the time of the creation of the Constitution. As with statutes, the plain language read in context with the entire instrument, the court will look to the state constitution not to determine what the legislature may do, but to determine what it may not do. Article 9, Section 1 of the Idaho State Constitution provides the stability of a Republican form of government depending mainly upon the intelligence of the people. It shall be the duty of the Legislature of Idaho to establish and maintain a general, uniform, and thorough system of public free common schools. Plainly, the Idaho State Constitution states that it is the legislature's duty, indeed, as many opinions of this court has indicated, a mandate to establish and maintain one system of public education that is general, uniform, thorough, public, free, and common. By its very language, the legislature may not establish and maintain another educational system outside of this single system.
Mr. Smith, before you get too far into your argument, let me ask just a question about the argument that the petitioners are making. It seems like from the briefing that the focus on House Bill 93 is all about the tax credits that are allowed to be used to pay private institutions. It doesn't the briefing really doesn't address the other components of House Bill 93, which allow for payments, for example, for tutoring, for SAT, ACT preparation courses, or the tests themselves. So are the petitioners challenging that aspect of House Bill 93?
There's a couple of levels to that, Justice. Obviously, the clear meaning, we believe, under the dictate of the Constitution is that anytime public monies are being funneled to private enterprise, even with those, that it is an impermissible funding. We understand that in the bill there is a severability, and other states have looked at that and has severed the tuition fees from those other qualified expenses. The other aspect that you have to look at that, though, is the fact that these expenses are not available to public school pupils. So on the one level, yes, the tax credits would be, we think, an impermissible conduit that is not available to the entire community and to public students, to answer your question.
So is the petitioner's position that the entirety of House Bill 93 should be struck as unconstitutional?
Correct. We understand that other states, specifically Kentucky, when confronted with that issue, have not accepted that total argument and has stated that those don't fall into the same category as tuition and fees, and have severed those off. And as I've stated, the bill does have a severability provision within it. And so that is an option that other states, when confronted with that, have severed those off. But once again, it's not available to all students in public school, and at the end of the day, the mechanism does flow to private depositories.
So you mentioned the public purpose doctrine and its relationship to these other fees. What would that do to the Idaho Launch Program?
The launch program, as I said, those are supplements that are post-primary education K through 12. They really not applicable since launch and, for instance, WWAMI. Article 9, Section 1 deals with K through 12. Launch and WWAMI are post-high school programs. So there'd be no effect whatsoever.
The public purpose doctrine wouldn't apply?
Well, the public purpose doctrine that we're narrowly construing, Justice, is Article 9, Section 1 that applies only through K through 12. Launch and WWAMI do not apply to K through 12.
But the public purpose doctrine stems from a different part of the Idaho Constitution. That is not an Article 9, Section 1 argument. So I want to build on Justice Brody's question. If we look at your public purpose argument, what happens to the launch funds, to WWAMI, to the other programs by which the state appropriates money to give to individuals to obtain different educational opportunities that they procure by paying those monies to a private entity?
Well, like I say, the petition is focused on, and I'll get to the question, narrowly construed right now. The petition only concerns itself with K through 12 education. And the public purpose doctrine, as we are applying it in this case to the petition, would not apply to those programs since they're post-secondary education and not applicable under Article 9, Section 1. The larger slippery slope that the Justice is suggesting is not contemplated, and I don't think there has been any challenge or contesting to those programs.
But isn't that part of our job from this court to look at, when we issue a decision about what are the ripples across the pond that our decision is going to have?
Well, it certainly is, but right now the court can only take up what is before it, and what is before it is the K through 12 argument that's in the petition.
So,
that we have to leave that for another day.
That, then, right before the questions, you had made a statement that the state has the duty pursuant to the Constitution to maintain one system. And I'd like to get back to that premise for a second. I don't think anyone's questioning that the Constitution requires the state to maintain a general, uniform, and thorough system. You read that provision of the Constitution to mean one and one only. And I'd like to ask you about that. What makes us assume that the Constitution basically treats the state as if they can't walk and chew gum at the same time? And by that I mean, as long as the state is maintaining, through their funding, a general, uniform, and thorough system of education, what prevents the state from tweaking its tax policy to allow parents to innovate and look into different forms of education?
The question raises I guess it focuses on the plain language. Under our interpretation of that language, Your Honor, it is a declarative statement as to the establishment and maintenance of a system, and also a prohibition as to any other system. There's nothing in the Idaho State Constitution that says that the legislature in its plenary power has the means, by any suitable means, to add to that. It only provides for a singular one system that is to be funded by public funds. To answer your question.
The statute at issue here, 603029N, is part of the tax code. The fact that it's numbered N suggests that there were 13 other tax credits before this one was issued. And I'm just wondering, is this really as much an education policy as it is a tax policy?
Well, I think it's anytime, as we learned in Tax 1, the taxing ability is really incentivizing where things are going to go and how things are going to develop. So, yes, it's...
hold on, just to clarify, it's incentivizing where the private sector goes, not where the public sector goes, correct?
Well, the ripple effect is on the public sector because those dollars, as we have put in our petitioning, it's going to have effect on what happens to average daily attendance because of the incentivizing of dollars into the private sector.
Doesn't average daily attendance argument go both ways, though? If there are less students in public schools, then it costs less to run them?
Well, that's certainly an argument, but, Your Honor, everything we're talking about is circumcised by the language of the Constitution. And as one court stated when it was wrestling with this question, we're not going to get into the wise or unwise applications of it. We're stuck with what the language of the Constitution says. We're not going to get into the cauldron of political sways as to what is best, because we now have to look at the plain language, and the plain language says it's one system funded by public funds.
Well, the plain language says it's a system, and I'm struggling with your argument because at the time the founders wrote and the state adopted our Constitution, Idaho's territorial statutes recognized that there were public schools and there were private schools. And I believe the year after or around that time that they adopted the Constitution, they also recognized parochial schools. So the founders, being aware that we had at least 3 kinds of schools, only one of which was public, if they intended to say the state could only appropriate money to public schools, why wouldn't they use one system of public schools as opposed to some other states have a provision in their Constitution that is specific. You can only appropriate public monies to public schools. We don't have any of that. And so I'm struggling with your argument that use of a system, a duty to create a system of public schools, automatically means that's the only system.
Well, in the context of the environment, the Idaho Constitution, when you read the commentaries on the debate, and this is stated in Justice Donaldson's dissent in Ingo King, there's a theme of egalitarianism, which is basically the result of the Horace Mann movement, that we're trying to get an educated populace. And the way we do that is we use public funds, public lands to fund that, so that we have an entire population that has access to the knowledge that they need to be part of the power and economic autonomy of a state. And the only way you do that is by a general, uniform, thorough education system funded by the state. The other, of course, answer to that is in the case of Evans versus Andrus, when this court concluded what the Article A meant in regard to trying to create 3 boards of education, wherein Section 2 of Article 9, the founders said you can only have one board, a board. And using that same perspective, we believe that when it says a system, that's the maximum singular standard for public funding.
But the context of Article 9, Section 2 is different, isn't it? You can't just take A out of context. The general supervision of the state educational institutions and public school system of the state of Idaho shall be vested in a state board of education. You have to read it all together, right? The supervision of state educational institutions is vested in a state board of education, one. Whereas Section 1, Article 9, Section 1 is different. It talks about it shall be the duty of the legislature of Idaho to establish and maintain a general, uniform, and thorough system of public, free, common schools. You have to establish one. It doesn't mean you are prevented. I don't see anything in that section that says you can't use state funds for anything else education related that may not be the system of public, free, common schools.
Well, once again, it does say A. There's nothing in Article 9 that says by any other suitable means they can concoct some kind of alternate system. And then you get into the canons of construction that we've put in our briefing, which is, I'd like to think that we're both reasonable people, and we have two reasonable explanations of that phrase in the Constitution. So if you use the rules of and canons of construction, like expression unicis imperii materia, when the Constitution and the framers speak as to one category, it prohibits the other.
I've never seen that canon employed in constructing a statute that provided a singular option. I've only seen that canon employed in situations where a list is provided. And even then, the case law counsel's exercising care because you have to determine the context of the list before you can determine whether the canon can properly be applied. So can you cite me to an instance where this court has applied that canon in an instance where a singular option is identified?
I cannot. The only reference we have is to the Florida Supreme Court, where they employed it by stating that when the Constitution prescribes the manner of doing an act, it is beyond the power of the legislature to enact a statute that would defeat the purpose of the constitutional provision. It also is allied to the doctrine that the legislature cannot do indirectly which is impermissible for it to do directly. And in that situation, the explanation we have is the legislature plainly is prohibited from directly funding private schools with appropriated public funds in order to offset tuition and fees. Likewise, the legislature is prohibited from doing indirectly by using parents as middlemen, where the ultimate result is appropriated public funds being used to pay private school tuition and fees.
And that argument hinges on your interpretation that the use of A in Article 9, Section 1 denotes only one as opposed to one.
Yes, we definitely argue that under the plain language, or if it's ambiguous, employing the canons of construction, that it can be only one.
Mr. Smith, before you run out of time, I want to give you time to an opportunity to address standing, because this court's case law has consistently held that you have to have a real injury to have standing. A speculative or a hypothetical injury is not enough. And when I read the declarations of your clients, I don't see where some of them allege a real injury and others allege what appears to be a speculative hypothetical injury that may or may not occur depending on what happens with this tax credit.
I understand the question, Justice, and I appreciate it. Of course, we believe that the petitioners have standing, and we've outlined that in our briefing. We also understand that the court has held that it's sufficient for this court to exercise standing where there's one petitioner that does have standing. We also believe that we qualify in this respect for relaxed standing. Consistent with this court's holding in Coeur d'Alene versus Denny, The present matter presents a significant and distinct constitutional violation of Article 9, Section 1, and there's no government agency or body that appears willing and ready to question the constitutionality of the statute. I guess the question is, if not us, who? And so we think that this is an answer that has to be given because this is a very, very significant question that has to be answered. So for those reasons, we believe that we do have standing.
So your-
Counsel,
Sorry, I was going to say, so your opponents have argued that the superintendent of public instruction would have standing, and that under our decision in Hawkins, the question is not whether they've actually sued, but whether somebody else actually does have standing. So would you address that argument?
Certainly. There's no question that they would have standing, but where are they in the court?
What do you think, what's her injury? I want to delve into that a little bit, because as I look at the Constitution, this statute, it doesn't appear to interfere with the superintendent's ability to administer public schools. And so what is the superintendent's injury that would give the superintendent standing to sue and seek a writ? Is it a funding argument? You're funding these things, and does she have standing to argue you shouldn't be funding those things? You should be giving that money to the state schools?
Historically, if you look at the funding cases where the superintendent did play a part, yes, that was the question. I mean, and it's a public funding, direction of public funds, the incentivizing that, as the declarations say, will make the administration of public schools much more difficult. And as I've already wanted to say, if somebody wanted to intervene in this matter, they could have sought intervention, but there's no one here but us to bring this question before the court.
But to Justice Zahn's point, if the superintendent doesn't suffer an injury as a result of the constitutional violation that you allege, doesn't that buttress your claim that you should get relaxed standing in this case?
Yes, it would.
so let me develop that a little further. Let's set aside Latah County School District for a moment and IEA and look at the other petitioners in this case. There's a variety of petitioners you've added to this that seem to have a very weak, if non-existent, claim to standing. You're asking us to find standing based on someone being a former state superintendent, based upon someone being a legislator that voted against this, someone being a grandparent. Is that a Pandora's box that this court should open? Do we seriously want to allow legislators that voted against a piece of legislation to have standing to challenge it in every instance? Or the fact that someone was a former state official, that automatically gives them standing to criticize future legislation? It just seems to me that you've added a lot of unnecessary petitioners to this case that actually weakens your standing argument.
Understand, your Justice. As I've said, it only takes one, and we're arguing for relaxed standing in this matter based upon the constitutional dimensions of the argument and the issue presented to the court, the urgency of the matter, and the fact that if it's not us, who will stand up for the public education
So
system?
you concede that there might be some questions about the standing of some of the petitioners?
Yes, Your Honor.
Who's your best petitioner?
Best petitioners are those who have a mission statement for schools, and those who have actually suffered discrimination already.
So would you be specific then? Who among your petitioners thinks makes the best case? If you could only go with one, who would you go with?
Well, it'd be those organizations, Your Honor, that have mission statements and have diverted funds that otherwise would be allocated to other issues. So I think those associations and then those individuals that have filed declarations with this court who have suffered already discrimination at the hands of a system about to be installed.
I understand what you're saying, but I'm not sure I heard an answer. So which of the named petitioners do you think, in your best day on court, you'd want to rely on?
Well, what those would be the first petitioner to protect the Constitution, the IEA, and those individuals like Ms. Morgan who have suffered discrimination,
Why not the school district?
and the school district from Moscow, yes.
Thank you.
Thank you, sir. Mr. Zarian?
Mr. Chief Justice, and may it please the court. After years of consideration, the Idaho legislature has devoted $50 million in tax credits towards providing Idaho parents with unprecedented ability to choose the educational setting that's right for their children. Petitioners may wish this money had been spent elsewhere as a matter of policy, but they presented no legitimate constitutional basis that would prevent the legislature's enormous investment in Idaho's next generation. On Article 9, Section 1 of the Idaho Constitution, petitioners still can't point to any text in the provision that imposes a limitation on the legislature. They ask the court to infer the existence of an implied limitation, but that's no different than asking the court to write words into the Constitution that aren't there. All the text requires is that the legislature establish and maintain a thorough system of public schools, and nobody here today disputes that it's done that. That should be the end of the analysis. As for the public purpose doctrine, the analysis should be easy. This law advances education, and education is a public purpose. There's nothing in the public purpose doctrine that says the government can't use private actors to help achieve the public purpose. In fact, such arrangements with private parties permeate this court's public purpose case law. The program's wide public benefits are only confirmed by its wide public support. Multiple recent polls show that roughly 2/3 of Idahoans support the program, and nearly 5,000 Idaho families have already applied for the tax credit. The court should not deny the public the benefits of the program. It should deny the petition. I want to start with Article 9, Section 1, and start, I think, as this court always does, with the plain text, which, as this court has noted and Justice Zahn was asking about, has no limiting language in it. It talks about a duty that the legislature must meet, and that is it. And that is consistent with what the purpose of the provision was, which is that at the time there wasn't a broad system of schools so that every child in Idaho could receive an education. And there's some quotes throughout the Constitution. I think the legislature had a good one, lamenting that so there have been some people who have grown up without the opportunity to be educated in Idaho. And so they wanted to make, the founders wanted to make sure that didn't happen, that everybody had a good public school to go to. And there's no dispute, the petitioners aren't claiming that there isn't a good public school for everybody to go to. So that complies with the purpose, and that's exactly what the text says. To read this as a limitation, it doesn't look like any other limitation in the Constitution. The other limitations say something like the legislature shall not do X or is strictly prohibited from doing Y. As Justice Zahn noted, it doesn't look like other limitations in other constitutions. I mean, California has one that looks exactly like what petitioners wish existed here. California's constitution, which was very influential at the time that Idaho's constitution was formed, says that no public money shall ever be appropriated for the support of any school not under the exclusive control of the officers of the public school. And that's exactly what they wish this provision says, but it doesn't say. And I think more fundamentally, there's a point that the petitioners are missing that doesn't show up anywhere in their briefs, which is that the legislature has plenary power to legislate on any subject. Unlike Congress, the federal Congress has to point to an enumerated power and say, this is what authorizes me to pass this law. And every law passed at the federal level cites the Constitution, says this is what my authority is. That's not the case in Idaho. The legislature generally can legislate on any topic and has a general police power to do so unless there's a limitation in the Constitution. And I think Idaho Press Club is the case that's most on point, and it talks about how this court, because of that plenary power, doesn't infer limitations on the legislature's power that aren't stated. It says we're not going to assume there are other unstated limitations. We're going to assume that the framers use caution and carefully crafted every provision of the Constitution. And here they didn't say anything about include any limitation or any limiting language in giving the mandate to the legislature to establish and maintain a system of public schools. I think other provisions of the Constitution just confirm that this wasn't meant to be a limitation. I think Justice Zahn again pointed to the fact that there were other schools at the time, but not only were there other private schools at the time that the founders knew about, they talk about in Article 9 private schools. There were other private schools at the time, and in Article 9 they talk about private schools, and they talk only about private schools controlled by churches and prohibited funding to those schools. And now that doesn't apply in this program here under the Free Exercise Clause, and there's been no challenge on that. But the point is that when they were writing the Constitution, they did think about private schools and talked about some private schools in the document, but didn't blanket prohibit funding of private schools. This obviously program doesn't fund private schools directly, but it just shows that they didn't impose any limitation on that, even indirectly benefiting private schools, as this program does. I think Article 10, Section 1 is another example of a place in the Constitution where we can see that the Article 9 was not meant to be the end-all, be-all of what the legislature can do in the realm of education. Article 10, Section 1, talks about creating other educational institutions, like an institution for the deaf and blind, which is, we have a K through 12 deaf and blind school. And so it just goes to show Article 9 can't be, I mean, there's a field preemption analogy that this is everything that you can do in the education space. That just can't be right. And Article 10 talks about how there's going to be other educational institutions. If Article 9 was the end-all, be-all, I mean, it doesn't even talk about a Department of Education. Could we create that? It doesn't talk about funding the schools outside of the endowment fund. It talks about some funding, but not other sources. Is that the exclusive source of funding? To say that Article 9 is just everything you can do, it flies in the face of the legislature's plenary power, and it just doesn't make sense and actually would be crippling to the educational system if that were true. The idea also, just going back on this duty language, that's the duty of the legislature, there are several duties in the Constitution that are spelled out, and I think it would be fairly nonsensical to read any of those as imposing a duty, and it just goes to show that, as imposing a limitation. So, for example, Article 20, Section 1 talks about how the legislature has the duty to publish proposed constitutional amendments in every newspaper that meets certain criteria. And I think it would be nonsensical to say, well, they gave you a duty to do one thing, and that means you can't do anything else. You couldn't publish notice on your website or on the TV, a TV ad about the constitutional, proposed constitutional amendments. And so the fact that a duty is given, all that says is this is a floor. You need to at least do these things. You can do more because you're the legislature and you have plenary power. This just says you have to at least do this, and that's what the legislature's done here. It's funded public schools, and to give more options to students to seek additional types of educations and ones that are more tailored to their needs. The legislature in this law and the Parental Choice Program has given more options.
Well, in fairness, though, the appellant's argument suggests this is more nefarious than that. They're suggesting that what the state is essentially doing through modifying its tax policy in a lot of ways is maintaining a separate but not a uniform and certainly not a free education system. Would you respond to that argument?
Certainly, Your Honor. It's not maintaining any system of schools. I mean, for example, not all of these funds even need to be spent at private schools. They could be spent at a bookstore to purchase a curriculum. It could be spent with tutors. So the argument would have to be this is a system of bookstores and tutors and schools that are all, none of them interact with each other. The money is reimbursed to parents who have spent that money at different places, at bookstores and schools and with tutors. But there's no system that is under the supervision of the state that it's administering, no system of schools. I think that would be like saying food stamps creates a system of grocery stores, is one analogy I saw, and that these are people who indirectly benefit from citizens of the state receiving a benefit from the state, but they don't interact with each other, they don't interact with the state. There's no system being created here.
Do students that are homeschooled, for example, or private schooled in other ways, do they have certain criteria that they have to meet in order to graduate? That are the criteria set by the state?
To graduate from homeschool?
To receive a GED or...
Yeah, I'm not sure. To receive a GED, I imagine that there's whatever entity administers the GED probably has requirements, but I don't know.
Are there any curriculum requirements on private schools or home schools that are similar to what we see in the public education system?
What we do have is that to be able to benefit, to be able to use these funds at a school, that school either needs to be accredited or it needs to document the growth of the student in some sort of portfolio of learning, which generally is what homeschools will do.
And who's it accredited by?
I don't know the names of all the organizations, but I know I learned it at
Simple
one
answer
point.
would be the state, correct?
I think it's an outside accrediting organization that that accredits private schools. I don't think the state accredits private schools.
So the state has ceded any control over what happens to private schools to an outside organization?
Well, the idea is that this to be able to receive for a student to be able to use this tax credit at your school, at a minimum, you need to teach English, math, science, and social study. There's some criteria, and you need to be accredited or document students' growth. And the tax commission intends on verifying those requirements, that they're always being met.
Again, I'm just getting at the source of the accreditation or the standards is who? Or is what?
That might be some Department of Education, but question of the Department of Education, perhaps the legislature knows. I don't know the answer to that question of who ultimately does the accrediting. And yeah, so I'd have to get back to you on that one.
If the state government is involved in that at all, isn't that maintaining a school system?
I don't know if that is maintaining a school system, the fact that there's some regulation on private entities who receive state funds. So I think no, the answer would be no to your question.
Mr. Zarian, I want to
Yeah.
give you a chance to address relaxed standing. And in your brief, you indicated, and I understood your brief, to primarily rely on the concession by the petitioner that the superintendent would have standing. As you could tell, maybe from my questions to him, I question whether the specific challenge in this case that's being brought, which is not an adequacy of funding public schools challenge, but is, these are my words, you cannot appropriate public monies that will be paid to a private entity for the education of an Idaho student. What would be the superintendent's injury that would allow the superintendent standing to assert that claim?
That's right. We mostly did rely on their theory of the case because at the standing stage, we generally assume the petitioner's version of the merits. And so we agree that it is not necessary that any school who indirectly benefits from any program that's involved, that the state implements, it's not necessary that they all be under the supervision of the superintendent of schools. But that is their theory, is that any school who receives any funding, even indirectly, must be overseen by the superintendent. And so this was similar, we thought, at least in Hawkins, the Department of Administration is somebody who was just administering the statute. It wasn't necessarily a harm that they could or couldn't dispose of a certain property, but it did interfere with, it did affect how they were going to administer that statute. And it seemed like under their theory of the case, that's exactly what's happening here.
So help me boil it down. What is the injury that the superintendent would have that would allow the superintendent to bring the specific challenge being asserted here?
Under their theory of what this law does, then their theory is the superintendent is supposed to be overseeing the private schools but can't oversee the private schools under the statute. But we disagree with that on the merits. And on the merits, I mean, going back to why if it's all right, Your Honor, they're going back to why there is no negative inference here. The negative inference of a duty, of giving someone a duty to do something, is that you don't give them a duty to do anything else. You have a duty to do X, and that means the negative inference is you don't have a duty to do Y. It wouldn't be that you don't have the power to do Y. That doesn't have anything to do with the words of the statute. And so that's just another reason why this theory of you have a duty to do one thing just can't be a negative inference. There can't be a negative inference that prevents this law. I'd like to turn to public purpose, if I could, quickly. And I think this court has been very clear that private means can be used to achieve a public end. In the cases, all throughout the case law, there's private hospitals that the state supports, and these private hospitals will end up serving the public health, and it serves the public at large. But that doesn't make it unconstitutional. It's kind of a good analogy is the Department of Transportation doesn't need to plow all the roads itself. It can contract for other people to plow the snowy roads. And here it's actually even a step more removed. It's contracted for someone else it's a step more removed because we're not contracting with private schools directly.
What about petitioner's argument that because this credit is not available to any parent who has a student in public school, that doesn't meet the public purpose doctrine because it's carving out for a a portion of the public.
Well, I'd start by saying that's not what the private purpose doctrine is getting at. The only time it's ever invalidated a law is when it's been a direct gift to one corporation or one family. Anytime it's applied beyond a single person or corporation, the court has never had a problem with it. There's a line in Kramer that talks about serving to benefit the community as a whole. But again, the requirement is just that it be generally applicable. And almost all of our public benefit laws have some sort of criteria in them.
Is it generally applicable when the majority of Idaho students attend public school? And so this credit actually only goes to a minority of Idaho students?
It's generally applicable in that any student could take advantage of it. And it's got neutral criteria.
Hold on. Any student who is not in public school. And so when the majority of Idaho students are in public school, it's not anyone who can take advantage of it.
That's right. Anybody who decides to meet the criteria and could go enroll in a private school, could be homeschooled. Anybody could take advantage of it in that sense. You're right. But you would have to meet the criteria. And I think so many of our public benefit laws have criteria. I mean,
Well, but my public school kid can't sign up for the program to get Princeton Review, but his brother who goes to a private school can, right? So, I mean, that's the way it works?
Right, but I also can't sign up for Medicaid tomorrow, and I also can't sign up for the Women, Infants, and Children's program tomorrow. There's just certain criteria that are baked into these programs that are meant to serve specific slivers of the community that we think is going to help, overall, is going to help the state, and we think that the education benefits of this program will benefit the state writ large in allowing more options for students.
This almost sounds like you're responding to an equal protection argument that appellants aren't even really raising.
Right. They tried to They've tried to slice it up and say you have to serve absolutely everyone. It can't draw these lines, but that's just not a requirement. That's not what the public purpose doctrine is even looking for. So these extra criteria, these layers that they've tried to layer onto the public purpose doctrine just don't have any basis in, this is already I was going to say basis in the text, but this is already an implied limitation. So it has no basis in this court's precedents interpreting the implied limitation at all.
So are you advocating that perhaps this court's language in past opinions stating that the public purpose must benefit the public as a whole swept too broadly? And
No.
as long as that it benefits some aspect of the public, that is a public purpose?
To the extent it means it literally benefits every person in the community, I don't think any public benefit law would ever pass that test, except for maybe a stimulus check where everybody just automatically receives it. There will always be criteria on when you can use it, and there will be, just because you have Medicaid or you're allowed to go to a homeless shelter, it doesn't mean that stops private people from excluding you from using that benefit, right? So hospitals don't admit everybody or don't necessarily provide you any treatment you want just because you have a public benefit to be able to use it. So I guess what I'd say is that, it did not sweep too broadly in that the goal was just to have a generally applicable law that benefits people. And it wasn't even a test that was applied in Kramer, but it was a sentence in Kramer, and I think that's what they meant. It's just that it be neutral and generally applicable, and anybody who meets the criteria can take advantage of it.
But, I mean, do we look at it that narrowly, or is it broader than that in terms of, going back to some of the opening remarks from the petitioner side, where they talk about our state benefits as a whole from having an educated population. So the fact that the program may be available only to a smaller group of students is immaterial, that we benefit from those students being well educated in whatever form the parents deem is appropriate for those particular children.
I think that's exactly right, too, Your Honor. And this goes back to Article 9, Section 1 in the sense that it talks about the form of the stability of our Republican form of government depends on the intelligence of our citizenry. And having a more intelligent and more educated citizenry is a benefit to everybody. And these are the future leaders of our state, and these people are going to do great things in their community. And so it is a benefit to everyone. It doesn't the quote that they've taken from Kramer was selectively edited to say it needs to serve everyone in the community. But you're right, it does say to serve to benefit everyone in the community. And everybody benefits from having an educated population.
I mean, and all citizens who own property, for example, get taxed by schools as taxing districts, even if they don't have children in the public schools, right? I mean, it's all because there's a public benefit as a whole.
Absolutely, Your Honor. Absolutely agree with that. And just the last point on public purpose, I think, Justice Brody, you brought this up, the launch program, and from a public purpose perspective, this is indistinguishable from launch in that, there are funds to be used at private institutions, and those institutions can discriminate on the basis of religion or whatever, but as long as you are able to use these, as long as you have incurred expenses at those institutions, then you can be reimbursed through the state through launch. So if this program were unconstitutional, so would that one. I just want to close by kind of going back to what I was just saying, in that I do believe the framers were right, and that the stability of Idaho's government does depend on the intelligence of its people, and that includes all of its kids, the kids who go to public schools, the kids who go to private schools, learning pods, micro schools, for whatever it may be, for one reason or another. And nothing in the Constitution prevents the legislature from advancing the education of all of these kids. And so we would ask the court to deny the petition.
Thank you, sir. Counsel?
Good morning, Chief Justice, members of the Supreme Court. May it please the court. I really want to very quickly follow up on Justice Moeller's questions with respect to accreditation. Generally speaking, schools in Idaho, including private schools and parochial Christian schools, are accredited by an outside private organization. Cognia is the name of it here in Idaho. It's the Northwest Accreditation Commission. So there is an outside authority that accredits that. With respect to the tax credit language, as far as...
Just to follow up on that then, and the requirement that they be accredited comes from where?
The requirement, well, there's no requirement that really any school needs to be accredited here in Idaho. The accreditation really gives individuals that participate in the school a feeling of security that there's appropriate curriculum that's being taught.
So then the answer to the question is the state plays absolutely zero role in ensuring the quality or the subject matter or the accreditation of any non-public school?
That's correct, Justice Moeller. That's correct. House Bill, or I'm sorry, the tax credit that is at issue here really has two components that is in line with your questions. The first one is they do require, in order to participate with the tax credit, they do require that academic instruction be taught in nonprofit schools. I'm sorry, in private schools. That academic instruction includes math, reading, writing, arithmetic. It's actually very similar to what the state Board of Education requires for public schools.
I guess what I'm getting at, if there is any requirement having anything to do with the state law requiring adherence to any standard for a private homeschool type situation, then doesn't that constitute the state maintaining a system of education?
Your Honor, there is no state requirements from an educational scope for private schools in Idaho. So, and to answer the question, I don't see, I guess, the triggering of maintenance of a private school system if there isn't a requirement.
But you just said they're required to teach math. They're required to teach certain subjects. It sounds like they're required by the state to do that as a condition of...
As a condition for the tax credit, to be available for the tax credit.
You see the really thin line here that I don't know if it resolves the case or not, but when I look at the constitutional provision and it talks about maintaining a system of education, I'm just wondering what constitutes maintaining, and if setting standards that they have to meet in order to qualify for the tax credit, if that is the equivalent of maintaining.
I'm not sure that the tax credit in itself requires private schools to maintain, or the state or the legislature to maintain a private school, especially if it's a voluntary tax policy measure.
So let me ask you, counsel, is it, I guess I'm wondering if the distinction is the tax credit is we will give you this is where you can spend it. You can choose from these options? And is there a distinction between saying, here are the places you may spend this money and maintaining a system of schools?
Yes, Your Honor, and thank you for putting it more eloquently than I just did. Certainly. I think from the start, we really need to talk a little bit about really what the framework is with respect to the analysis. And Justice Zahn's opinion in the Athletic Commission case, it really provides the framework for what's being considered here. You have to take a look at the plain language. It always starts with the plain language. That's part of the interpretation. Part of the interpretation is also about what the framers' intent were. And you don't really have to look very far to delineate where the framers' intent was, because the first clause of that provision says, the stability of a Republican form of government depending mainly upon the intelligence of the people. They wanted more smart, educated Idahoans. That was their purpose. That was their intent, to establish a public school system. It's a vehicle to get what they need, more educated people. What the petitioners are arguing here is to say, well, the state of Idaho legislature, your plenary power is now limited. You can only look at the public school system as a solution to education. That does not further the framers' intent. If you look at the words, you don't have to look at a lot of the, well, as Justice Zahn had expressed in her opinion, you don't have to look at principles of statutory construction, because interpretation is really all that's required. If you do look at the interpretation, expressio unis doesn't really apply here. You're correct. The vast majority of times, expressio unis is really about a list that's delineated, and because of that list, you can't do anything else. In this particular case, while they didn't talk about expressio unis in the Deford case, they did address a similar type of analysis. In that provision, in that case, the defendant there challenged the income tax here in the state of Idaho because it wasn't one of the three express methods of taxation under the Constitution. And back then it was poll tax, a license, and property tax. In that case, the court really said, while it is true there are three methods of raising revenue expressed in Section 2, Article 7 of the Constitution, we cannot infer from this that an implication arises prohibiting the state from also raising revenue taxes, raising revenue pursuant to the inherent power to do so in any other manner its legislature may see fit to adopt. In this case, it's stronger because we already had the framers' intent in the first clause of that section. We want more education to preclude and to tie the legislature's hands from considering educational policy issues outside of the education system will create disastrous effects, not to mention inconsistency with the framers' intent. I'll stop for questions if you have any. If not, I'll address Justice Zahn's line of questioning with respect to the plain language A, which is a consideration because it is part of the interpretation of the language. A doesn't mean one in every single situation. We know that. It could mean one, it could mean a class of individuals. A justice, for instance, doesn't mean that there isn't 5 justices here in front of me. Not only that, Your Honor, if you take...
It's the context that matters, right?
Absolutely.
So what's the context here that doesn't exclude it to just one single
That's
option?
right. If you read the language in context, it just is. A could also mean an introductory to a thing or person or verb. So to establish and maintain a public, system of school, a system of public free common schools. That's exactly what it means. If you take a look at another context, if you take a look at Article 7, Section 4, they use A. In part, they say, however, an unimproved real property owned or held by the Department of Fish and Game may be subject to a fee in lieu of taxes if the fees, now plural, were authorized by statute. In that context, just as Justice Mueller had expressed, it's different. It's not one. In fact, the language tells you right there, it's more than one.
Help me understand that. So, for example, if my wife were to tell me that I can have a scoop of ice cream for dessert, and I come back with 2, I think it's pretty clear that I violated that mandate. So why is this different than that?
It depends on the context, right, Justice?
Yeah, so explain the context here,
Right.
why it's different.
For instance, this morning, I told my kid, hey, you can have a donut, but that doesn't mean that I couldn't also cook up some bacon for him later. That's,
Yeah, but if your son took 2 donuts, you would feel like you'd had your edict violated, wouldn't you?
well, a donut. Or a
Doesn't
sprinkled
it-
donut as compared
Mr.
to...
Chu-
I'm saying there isn't a difference. I just want you to explain the difference.
Right. I think the difference in the context of Article 9, Section 1 is that it's introducing a general, uniform, thorough system. There's nothing in the language that you can utilize to imply that it's a limitation, that it's only limited to one. The Evans case was different because they were talking about an institution. And in that case, it really was even just one Board of Education. What the court was concerned in that case about was really about the creation of the councils within the Board of Education that was autonomous, meaning they didn't answer to the Board of Education. That was really the issue there that they had a problem with.
Isn't really the better way to look at it the difference between a duty and permission? Aren't those 2 different things, whether this statute is permissive versus whether it is just directing a duty?
Well,
For example, I give you permission to buy a donut versus you must buy a donut. One of those, I think, suggests that you can only get one. The other might suggest you can get 2.
yes, Justice. There is no argument here that there is a duty to maintain a general, uniform, thorough system of public free common schools. That's not even an issue here. There's not a contention that we're not living up to that duty. The question is, does that language prevent us from considering other things? And they characterize this tax credit as a parallel system of public school. It's really a mischaracterization.
Well, that's...
All right, are you going to continue questioning? He's way beyond time.
Oh, I'm sorry, I didn't realize that.
I apologize.
Chief, may I ask one more question?
One more question.
Yeah, so in my very first question to Mr. Smith, I suggested, are we saying that the state can't walk and chew gum at the same time? You acknowledge that the state's ultimate duty is to maintain a system. To what degree, then, can anything secondary they do interfere with that?
Your Honor, I think the answer to that question is not necessarily is
Wait a
the
minute, I'm
tax...
having real trouble following you while a phone's ringing in the court. We have signage all over this building saying don't bring phones in this room. I don't know what more we can do about that, but it's very disturbing. If any of you have phones with you, please turn them off. All right? Thank you. You may proceed now, and if you could restate your question. Frankly, I forgot where we were.
If I can remember. I guess the key point I'm talking about here is just because the state has a duty to do A, they may be free to do B as long as B doesn't interfere with A, correct?
I think interference is the point that I'm having trouble with.
Right, because that's the theory of their case, is that it's interfering.
Right, because the tax credit here is not interfering with the public school system. It's not taking appropriation money that's dedicated to the public school system. It's frankly not even addressing the public school system. So that's why it just gives me a little pause to, I guess, characterize that as maybe interfering with the public school system. If anything, it's supplementing. It's making sure that kids that don't flourish, or parents who have a right to decide what kind of education their child gets. At least this tax credit provides them with a little opportunity to look at education outside of the school system, not to interfere, but to look outside.
Thank you. Do you have a question, Justice Hahn?
No.
Anyone else?
Thank you.
All right. Thank you, sir.
Thank you so much.
Madam Clerk, how much time does the petitioner have remaining?
6 minutes, Your Honor.
Thank you. Mr. Smith, you may proceed.
Chief Justice, Justices of the Supreme Court, the framers of Idaho's Constitution did not have to include within the Constitution's framework a public education system, but they did. The Idaho Supreme Court in Thompson versus Engelking clarified that Article 9, Section 1 is, quote, is a mandate to the state through the legislature to set up a complete and uniform system of public education for Idaho elementary and secondary students. The Idaho Supreme Court has held that when reading the Constitution, the court will look, quote, look to it not to determine what the legislature may do, but to determine what it may not do, end quote. I'd like to address this whole floor versus ceiling argument because I believe that that argument mischaracterizes the issue regardless of where the floor or the ceiling is located. At the heart, this law creates a program that takes public taxpayer money and creates a parallel system of education that is not regulated under the law, thereby creating an unregulated parallel scheme of education. Notably, one of the main cases cited to by the Tax Commission is a case out of Wyoming, Davis v. Grover. And it's important to note in that case, under that program, the participating schools, which were private schools, they were required to comply with various state standards, including non-discrimination, health and safety codes applicable to public schools, and submitting to financial and performance audits by the state. By contrast, this law, HB 93, states that its provisions shall not permit any government agency to exercise control or supervision over any non-public school or to give the state authority to regulate education of non-public students. And that's under Idaho Code 63-3029N, subsection 2.
Don't you think that might be a response to the U.S. Supreme Court's Espinoza versus Montana ruling in 2020 and the Blaine Amendment and the effect that that had on that?
I don't believe so, because in that case, it was just talking about whether those funds could be used to fund not just private schools, but religious schools as well.
Right.
And I don't think requiring regulations such as health and safety codes or non-discrimination would deal.
Well, when you talk about non-discrimination, though, I think that's where it ties in with the Blaine Amendment, right?
It could, definitely, but not with the health and safety codes.
No, not there, of course.
And I think that leads me to my next point. I just wanted to emphasize a couple things about the...
Before you do that, though, you mentioned that in HB 93 there's no regulation by the state of these private schools or other entities. Doesn't that cut against the argument that the bill sets up a separate system of schools?
No, I don't believe it does. It sets up...
Explain that.
Well, because it sets up a separate system that's unregulated.
And how does it set up a system? I know there's been a lot of discussion among the attorneys so far.
Sure. Well, obviously, it sets up a system, well, not only a system, but it maintains that system because public funds are going used to maintain these private schools. And so when money is being used on a separate parallel system, it's maintaining that system of education.
When you call it a system, it seems like that's kind of an exaggeration of what we see in non-public education. Don't we see just a lot of innovation, typically from parents or groups of parents, to do things a different way than our public school system does? That doesn't sound like a system where there's as much diversity in non-public education.
Well, and I think, the word system, a synonym or another definition is a methodology. So I think you could say that what we're doing here is maintaining or establishing not only a separate system, but maybe a separate methodology. Like you said, there's many different ways that parents can choose to educate their children. And in using these funds, you are maintaining a different parallel methodology of doing that.
But I don't understand that definition. I don't understand how that would work. I'm thinking of our public school system, and I alluded to the fact that I had a public school kid. He graduated from Renaissance High School over in West Ada, and that's a public school, but not every child gets to go there. You have to meet certain criteria in order to be in the AA, or he was in the International Baccalaureate program. Not every public school is the same. The Treasure Valley Math and Science Center here in the Boise School District, not every child gets to go there. If you're a kid that's going to be studying differential equations, you get to go there, but not everybody gets to go. I mean, so this idea that there's different methodologies, I mean, we see that within the public school system. Not all schools are the same.
That's true. Not all schools are the same, but when that criteria is met, those public schools take those students. In this case, you could have a family who meets the criteria for the tax credit, but it's ultimately up to the private school whether or not they will accept or admit that student. At the end of the line of this bill, you have a private gatekeeper who's saying, even if you meet the criteria for the credit, they can still say that we will not admit you to the school.
Would you, if I might, if we find that House Bill 93 is constitutional, would you please address the availability of attorney's fees against the school district? And what I'm asking specifically is whether you agree with the state's analysis that it is a political subdivision, it is a taxing district, and under 12.117.4, fees are available, in fact, mandated.
Well, and obviously I believe we addressed that in the briefing, and I'd rely primarily on that in the briefing, but I would agree that attorney fees would be available to the Moscow School District under 12.117.
Any additional questions, petitioners? Very well, sir. Thank you. If this matter is now under advisement, the court will render a decision in due course. We will now be in recess until February 11, 2026.